One moment.
Good afternoon, everybody. Welcome to Abortion, Choice, and the Supreme Court. This is part of the American Historical Association's History Behind the Headlines series. My name is Jim Grossman. I'm the Executive Director of the American Historical Association, the largest professional organization serving historians in all fields and in all sorts of workplaces and professions. The AHA promotes history education, professional work of historians, and the critical role of historical thinking in public life, which is why we're here today, because we believe historians and historical thinking has a critical role in public life. Today's event is part of the AHA's History Behind the Headlines series, which features historians providing historical context for current events, suggesting how historical thinking can provide different angles on the world around us. The AHA's History Behind the Headlines series is generously sponsored by AHA member Jared Brubaker. We're very grateful to him and to our other members for their support of our work. We can't do any of this work or any other kind of work without the support of our members. We hope those of you who find this program worthwhile will consider joining the AHA. We have many members who are not professional historians, but who like to read history and learn from reading history or listening to history. Today's discussion, which will run until 4 p.m. Eastern Time, brings together 4 leading scholars to place the U.S. Supreme Court's recent decision in the case of Dobbs versus Jackson Women's Health Organization in historical context. They'll consider how we arrived at this moment, almost 50 years after Roe v. Wade, and why history is central to this jurisprudence and its implications. Our discussion will be moderated by Leslie Reagan, Professor of History at the University of Illinois, Urbana-Champaign, with also affiliations in gender and women's studies, media studies, and law. Professor Reagan's very busy. She is the author of When Abortion Was a Crime, Women, Medicine, and Law in the United States, 1867 to 1973, which I can assure to the non-historians in the audience is the go-to book, and has been for some time, go-to book on the century when abortion was illegal across the United States. She has also published the award-winning Dangerous Pregnancies, Mothers, Disabilities, and Abortion in Modern America. Professor Reagan appears frequently on National Public Radio, has written for the Washington Post, Slate, and Ms. Magazine. Leslie, it's all yours. I'm going to go away now. I'll stick around here, though.
Sorry, I'm now unmuted. Thank you, Jim. I am honored to be part of this really important webinar on the Dobbs versus Jackson Health Clinic case and Supreme Court opinion. So I want to say thank you to Jim Grossman, Hope Shannon, and all of the AHA staff who are working behind the scenes to make this conversation possible. First, I will introduce our speakers, and then I will ask specific questions to each of them, and we'll have kind of an open conversation among us. So let me introduce first Nancy Cott. Nancy Cott is Jonathan Trumbull Research Professor of American History at Harvard University. She retired in 2018 after teaching U.S. history, focusing on gender questions at Yale and Harvard. Her books include The Bonds of Womanhood, The Grounding of Modern Feminism, Public Vows, A History of Marriage and the Nation, Fighting Words, The Bold American Journalists Who Brought the World Home Between the Wars, and as co-editor, Intimate States, Gender, Sexuality, and Governance in Modern U.S. History. Welcome, Nancy. Melissa Murray is Frederick I. and Grace Stokes Professor of Law at NYU School of Law, where she teaches constitutional law, family law, criminal law, and reproductive rights and justice. Her writing has appeared in a range of legal and lay publications, including the Harvard Law Review, the Yale Law Journal, the New York Times, the Washington Post, and The Nation. Prior to joining the NYU law faculty, Murray taught at the University of California, Berkeley, and served as interim dean of the law school. Murray is a legal analyst for MSNBC and co-host of Strict Scrutiny, a crooked media podcast about the Supreme Court. And she has clerked for Sonia Sotomayor, then a judge of the U.S. Court of Appeals for the Second Circuit, and Stefan Underhill of the U.S. District Court for the District of Connecticut. Welcome, Miss Melissa. Aaron Tang is professor of law at the University of California, Davis, and former clerk to Justice Sotomayor. He writes about constitutional law, education law, and the Supreme Court. His scholarly work has appeared in the Stanford Law Review, Columbia Law Review, and elsewhere, and he has written for popular audiences in the New York Times, the Washington Post, the Los Angeles Times, Slate, and the Atlantic. So welcome to all of you, and welcome to our invisible audience out there, and thank you so much for being part of the panel today. So first, I want to go to you, Melissa, and ask you, we're thinking most of our audiences has read some of the decision probably. What are the most important points about this opinion that historians should know?
Well, thank you for having me, Leslie. It's really great to be here. I should say at the outset, I'm not an historian by training, but I think I'd like to say I have an historian's heart, and I am very sympathetic to all of the arguments that historians have made about law. And indeed, I am incredibly sympathetic to the brief that the AHA filed in the Dobbs case. So many thanks for that. Let me start first by maybe laying out what the opinion does to make sure that we're all on the same page, and then I'll talk a little bit about how it does that. So the opinion is written by Justice Alito. There are basically two parts to the opinion. One part that upholds the Mississippi 15-week abortion ban that was the subject of the legal challenge. And then the second part that overrules Roe versus Wade and Planned Parenthood versus Casey, the two principal opinions that are the pillars of the court's abortion jurisprudence. The court got 6 votes to uphold the Mississippi statute, so the 5 core conservatives and the Chief Justice, but only got 5 votes to overrule Roe versus Wade and Planned Parenthood versus Casey. Justice Alito makes very clear in the majority opinion, which is not substantially different from the draft opinion that was leaked in May, that the right to choose an abortion is not deeply rooted in the history or traditions of this country, nor is it explicit in the text of the Constitution. And for that reason, it is something of a constitutional apostasy. More importantly, he notes that previous cases that had affirmed and upheld the right to an abortion really overlooked essential factual circumstances and therefore missed the whole view that this was not something that was deeply rooted in the history of this country. And for that reason, the right to an abortion could be properly reconsidered and Roe and Casey could be properly reevaluated. That means, as a matter of methodology, the debate in this case was a war between two different historiographies of the right to an abortion. And so I think it's worthwhile to sort of suss out what those look like. In Roe versus Wade, Justice Harry Blackmun sketched a picture of abortion regulation in the United States that essentially noted that the laws of the United States really tracked the common law of England insofar as abortion is concerned, which is to say that women enjoyed a right, an opportunity to terminate a pregnancy so long as it took place before quickening, that point in the pregnancy where fetal movement could be detected, when a woman was quote unquote quick with child. After quickening, then there were more restrictive penalties, sometimes even criminal penalties, but for the most part, in the period preceding quickening, there was liberal access to abortion on the view that childbirth often bore more risks and was more threatening to the life of the pregnant woman than was the prospect of terminating the pregnancy, right? Justice Blackmun also notes that there is a sea change in the regulation of abortion. In the period following the American Civil War, there had been some efforts to regulate abortion in advance of that, but it really picks up in the period following Reconstruction. And he notes that quite a lot of this activity was spurred by the work of physicians who were professionalizing, becoming, the American Medical Association is created at this point in time, and the field of obstetrics and gynecology is really coming into its own. And one of the things that it wants to do is really root out the faith healers and midwives who had previously dominated the business of birth. And so part of this campaign is to criminalize one of the most potent avenues in which midwives and faith healers had worked with pregnant women in the termination of pregnancy. So what follows is a campaign that is augmented by demographic anxiety about the changing character of the United States as fewer native-born white women are having large families. They are choosing voluntary motherhood and contracepting, and in some cases terminating pregnancies in order to keep their families at manageable sizes, while their darker hued immigrant sisters are actually having very large families, and this threatens the demographic character of the country. And so Justice Blackmun is sort of sketching all of this and comes to the conclusion that there is no deeply rooted tradition of criminalizing abortion in the United States. And in fact, there is actually broad support for the view that there is some liberty for women to elect to terminate a pregnancy at certain periods in the pregnancy and at certain points of gestation. And so he finds that this right to privacy that had previously been announced in 1965's Griswold versus Connecticut is capacious enough to include the right of a woman to terminate a pregnancy in consultation with her physicians. And to be very clear, he's very concerned with the rights of doctors who are criminally liable and professionally penalized if they are found guilty of these criminal statutes prohibiting abortion. And he had previously been the general counsel for the Mayo Clinic, so this really hits home for him. This is one history. It's very different from the history that Justice Alito sketches in the opinion that overrules Roe and Casey. And Justice Alito basically challenges this view that the common law tradition allowed for abortion prior to quickening. He argues that while there is some evidence to suggest that this occurred, for the most part, the moral condemnation of abortion as a practice was consistent throughout the common law period, regardless of whether abortion was permitted before quickening or not. He then traces this forward to the 1820s, where there's a slow and itinerant sort of commitment to restricting abortion in certain cases. And then he develops this more muscularly in the Reconstruction era restrictions on abortion. And he takes all of this together, drawing from some other common law sources, including Sir Edward Coke and Sir Matthew Hale. Sir Matthew Hale is notable because he advocated for the burning of women as witches, and notes that there is a strong common law tradition of moral condemnation of abortion, as well as legal prohibitions on abortion. And with that in mind, he notes that at the time the 14th Amendment was ratified after the Civil War, there was no tradition that would have allowed for a right to an abortion. In fact, abortion was broadly condemned in almost every state in the Union. He then goes forward to note that this persisted until the 1960s, where there was some debate over the question of abortion and some prospect of liberalization on the state level, and then this was interrupted by the court's decision in Roe versus Wade in 1973. He then reinvokes the view that a fundamental right can only be a right that is deeply rooted in the traditions and history of the United States. This comes from Glucksberg versus Washington. It is a view of fundamental rights that I think has largely been abandoned, or at least was abandoned in more recent cases like Obergefell versus Hodges, which legalized same-sex marriage, but it is resuscitated in the Dobbs case. And this becomes, in Justice Alito's view, the only criteria for understanding what a fundamental right is. Having concluded that there is no history that embraces an abortion right in the United States, he concludes that this right cannot coexist with the constitutional principles that we have today. For this reason, the Roe opinion, which did not take into account this history, did not take into account this analysis of fundamental right, was incorrect when it was decided. It is egregiously wrong, and it is now overruled. And so that's sort of the warring historiographies that we have in this opinion. And again, it's very much at odds with some of the views that other historians have taken. And I will note that although Justice Alito is not an historian by trade, which means he could certainly join the AHA, and perhaps based on Jim's account, maybe he should, because it would be a great opportunity to learn from actual historians. I'll leave it there.
I like that idea. We recruit the Supreme Court to listen to us. Nancy, can you tell us more about what historians have to say about the history of abortion and, I guess, well, what I call the real history?
Sure, thank you. And thanks to Jim and Hope and all those who have set this up. I think that Melissa has already done a considerable job in sketching this history, but let me take it outside of Blackman's opinion or the Casey opinion to a broader and very roughly sketched historical consensus about what I might call periodization in the history of abortion. First, there's a long history under the common law, and that, of course, precedes the establishment of the American colonies and is coterminous with the colonial era, and then covers the early United States up to roughly the 1820s, because in the 1820s and afterwards, states began to pass their own positive laws in order to supersede the common law. But as Melissa mentioned, it's clear from every consideration I've seen in American texts that the common law, as understood by Americans, meant that no such crime as abortion could be recognized before the stage of quickening in a woman's pregnancy. And I want to point out that quickening, which is often pinned, and I mean, Justice Blackmun and Roe, in fact, pinned it to most often between the 16th and 18th week of pregnancy, is not a scientific definition. It is the period when a woman felt the quickening. And so it is a subjective phase, and only the woman involved can announce whether it's there or not. This point that it's really the woman and no medical specialist who can say was, I've seen it mentioned numerous times in medical jurisprudence texts of the early 19th century. So it seems to me that is an important precedent in American history and traditions for a woman's liberty to say whether she has a pregnancy that is worthy of legal consideration. And another concern there is, as opposed to the way Alito interprets the common law on other sources, which perhaps we can discuss later, it's clear that there is no other interpretation of what the common law meant than this quickening barrier or measure being very significant. Blackstone, the legal theorist of the common law relied on by the US, says a being is in existence in contemplation of law as soon as there's quickening in the mother's womb, and not before, in other words. So it does seem from more ancient sources that under common law, abortion was a crime after quickening. But there are at best 3 examples in all of the colonial archives of such an abortion being noticed even or prosecuted. And the best case is one that Cornelia Dayton wrote an article about years ago, very well documenting an intentional abortion in which the woman died. And therefore the provider was prosecuted. This was clearly after quickening, and also there's a lot of good information about that case. And then 2 others are much more fragmentary and less certain. However, let's move ahead. The phase of beginning criminalizing of abortion, principally, again, after quickening in American positive law, began in the 1820s and then advanced really quite slowly up to the period of the 1860s and went on after, so that it wasn't entirely complete until the end of the 19th century. And what's notable is that numerous states, probably at least a third of the states, including the state of Mississippi, which brought this case, retained the common law distinction between pre-quickening abortion which was either not a crime at all, that is the case with Mississippi, or was considered a much lesser crime than any termination of pregnancy after quickening. And what's important here is what drove this change in laws. And there are several factors that coalesced. One certainly was increasing scientific knowledge on the part of medical people who began to know, if trained, that quickening actually didn't mean anything in the progress of a pregnancy, but it was continuous from conception to birth. So they wanted to discount the quickening phase as meaningful vis-a-vis terminating a pregnancy. And secondly, I would say women's deaths in abortion that began to be publicized. So a third feature that was really crucial to criminalization of abortion is journalism. That is, once people were collected in cities, more unruly sex was going on, more women, by and large, unmarried women in the early 1800s were seeking abortion, and many of them died from poor providers, either through toxic potions they took or through an attempt to end a pregnancy through some sort of invasion of the uterus. And it was deaths of women that actually prompted public attention. And it's really quite striking as one looks at any sort of legal prosecution after a woman's death that is suspected to be from an abortion, that the concern for the fetus is amazingly, almost shockingly absent. Justice Alito's focus on the moral condemnation of abortion is, I think, overemphasized. But what the point he misses that is really crucial in understanding the social context of abortion, or why it was not seen positively, is that it was associated with unlawful sex. It was not that it was associated with the ending of an unborn life. Abortion was seen as evidence, as infanticide was typically seen, of trying to cover up what was really the crime, sex outside of marriage. And this is so clear when you look at early trials, even in those states where abortion was a positive crime on the books, that juries and judges, for that matter, were extremely sympathetic to the unmarried woman who sought an abortion. Even if they believed abortion was unlawful, they said time and again, you can see this, and in legal treatises as well, you can understand why a woman would want to avoid a life of dishonor, that is, the dishonor of having an illegitimate child, and would seek something like this. So this is a crucial element of moral disapprobation of abortion. So I would say, probably increasing abortions, among a minority of the medical profession, the realization that quickening meant nothing, the journalism that publicized these things, and then just as important, as Melissa alluded to, there is evidence that comes to the public that not only single women, but married women are seeking to use abortion as a means of regulating their families and not having completely unregulated fertility. And in Massachusetts, for example, the law criminalizing abortion happened after a abortion provider who ran a house that allowed such things to happen was arrested, having successfully terminated the pregnancies of 3 married women. And that abortion provider, who was a woman, which was not always the regular, many men were the people early prosecuted, was let off by the Massachusetts Supreme Court because they were still under the common law. And there was no evidence these were pregnancies past quickening. There was no crime. So it was probably doctors' pressure on the legislature at that time to say, how can this be that within a year, the Massachusetts legislature passed a law making abortion a crime. So,
Nancy, oh,
Yeah.
can I stop you for a second?
yeah, I'm taking too long.
No, you're doing great,
Yeah,
but
yeah.
and you've brought up such important points about this is about sex and
Yeah.
and marital status, which of course sex is absent in the current opinion.
Mhm.
So if we could give Aaron a chance here, and
Sure.
we'll come back to you.
Sure,
Um,
sure. I want some point, we need to come back to the doctor's campaign
Yes.
to make it a crime more definitely, which didn't occur until the 1860s.
Yeah, really important point. Aaron, maybe you'd like to tell us a bit more about where Alito and the opinion gets it wrong in terms of their legal history.
Sure. On page 47 of the majority opinion, Justice Alito says the most important historical fact that leads him to conclude Roe was egregiously wrong to find a right to abortion is the fact that at the time the 14th Amendment was adopted in 1868, 3/4 of the states, he says 28 out of 37 states, criminally punished abortion at all stages in pregnancy. The most important historical fact, so important that he repeats that exact line verbatim 4 times in the opinion. 3/4 of the states punished abortion. He includes a 22-page appendix, which is longer than most Supreme Court majority opinions, documenting each of the 28 states that he says banned abortion throughout pregnancy. It's not just Justice Alito. Justice Kavanaugh writes separately to underscore. He says, as I see it, the dispositive point is that in 1868, this many states criminally punished abortion. So you asked me, Leslie, what does Justice Alito's opinion get wrong? It gets wrong the most important historical fact, because it is not a fact at all that 28 states punished abortion throughout pregnancy when the 14th Amendment was ratified. The true number of states, the true answer is I don't know. I'm not a trained historian. I don't know how many states. I have some evidence that it's much less than 28. I think it's more like 16 out of 37 states actually banned abortions throughout pregnancy, which means a majority of the states continued this centuries-old quickening understanding that women were free to terminate their pregnancies up to 16 to 18 weeks in pregnancy, no criminal prohibitions at all. But there's evidence on both sides. I'll just emphasize or highlight a few of the really glaring mistakes that Justice Alito makes without any sort of assessment or analysis. So 2 of the states he lists in the 28 that are in his appendix are Nebraska and Louisiana. Those 2 states only ban abortions as of 1868 via noxious poisons. Notably absent is language banning abortions or prohibiting abortions if they're done via instrument, which is language in every other abortion statute, or other means. Right. So the rule in Nebraska and Louisiana, which makes sense, can't poison a pregnant person, but a safe instrumental abortion, no criminal punishment at all for the provider. He lists Alabama on among the 28 states, even though the Alabama Supreme Court held in an 1857 case construing its 1841 statute that 1841 statute only punishes abortions after quickening, just as was true at common law. Oregon state prosecutors admitted the same thing about their law in front of the Oregon Supreme Court. They said, yeah, this statute of ours only punishes procedures after quickening. No surprise, continuing the common law tradition. Texas, actually, the Texas Court of Criminal Appeals recognizes in a 1915 decision that the legislature amended its statute from 1858. It fixed it in 1907 to reach abortions performed on an embryo, precisely because it wanted to change this quickening rule 4 decades after 1868. Justice Alito, here's a glaring mistake. He cites as operative in Virginia to show that Virginia banned pre-quickening abortions. An 1848 law that was actually repealed 10 months later. The 1848 law explicitly punishes pre-quickening abortions. The 1849 law that replaces it takes out that explicit punishment. There's a lot of evidence. An 1856 Virginia Medical Journal article written by an anti-abortion doctor looks at that statute and he laments. He says, how can we not protect fetuses before quickening or human life before quickening in this state? Strong evidence that Virginia is also miscounted. So I won't go through every number, but the bottom line is the most important historical fact in Justice Alito's opinion is not really a fact at all. It's contested. I do want to say, and I'll say this with some apologies to the AHA, and maybe this means I'll never get invited to join an event again. I don't think we should overemphasize the role that history played as a realist matter in Justice Alito's opinion. Practically speaking, politically speaking, the truth, I think, is history is pretty much irrelevant to what Justice Alito and the other 4 justices are trying to do, which is to say, even if they were convinced that some smaller number of states banned abortion throughout pregnancy, 16 or some other number, they would have reached the same outcome. Maybe they would have just said, well, 16 is enough. Maybe they would have changed the test to be something even more restrictive of rights. One way to maybe summarize the point is when we think about what the Supreme Court does and why it does it, there are reasons and there are excuses for what the Supreme Court is doing. And I think history here is an excuse. It's an instrument that Justice Alito is using to arrive at an outcome, that is a canonical position among members of the Federalist Society, the 5 members of the majority that have been trained as with this as an ideological litmus test that Roe should be overruled by any means necessary.
Thank you, Aaron. Probably many historians would agree. History is an excuse in this opinion. Nancy, do you want to talk some more, Nancy and Melissa, about why there is this difference between the Alito version of history and his comrades and historians' understanding of history?
I would like to follow up directly on Aaron's comment, which I think is very well put and reminds me of a comment that Tomiko Brown-Nagin made at a panel on historians and amicus briefs that was held a number of years ago at the Organization of American Historians. And she said, very similar to Aaron, when the history goes in the direction that the judge, that the justice already wants, sure, call on history. When it doesn't, leave history aside. Another reason that of course, the opinion had to at least consult history is that the Roe decision relied on it to such a great extent. While people generally don't remember that because privacy is the tenet on which the opinion rests, it's a surprise to go back to the Roe versus Wade opinion and see that about, I think, 20 pages of it is Blackmun's investigation of the history because of this need to show that a fundamental right resides in the history and tradition. But just there is a major question. Where and when do history and tradition end, let's say, if we can show on the common law interpretation that is, I believe, unquestionably correct, that there was a great freedom for abortion before quickening that lasted up to roughly the 1860s. Isn't that enough? That this history and this tradition, you can find it in public opinion among juries, for instance, and being lamented by certain medical professionals up to the early 20th century. But no, Alito prefers this argument that the history and traditions have everything to do with the period when the 14th Amendment was passed, 1868. And this view, this alternative view, first of all, of the great meaning of the 14th Amendment's protections of every person's life and liberty, has been pushed by certain anti-abortion voices, many of them lawyers, ever since 1973. And I don't know whether anyone recalls or has studied that as early as 1982, there was a proposal to add a human life amendment to the US Constitution, and hearings were held in Congress about it. And James Witherspoon, who wrote a very important early argument based on looking at 1848 at the 14th Amendment and which states had criminalized abortion. By that point, Witherspoon wanted to argue, and he also put this into a law review article, that actually the 14th Amendment protected the fetus in the womb from its conception, that guarantee of life and liberty pertained to human embryos and fetuses. Now, he did not get very far with that claim, certainly not in the hearings, where historians Carl Degler, who was extremely well known at the time on family and sexual issues and American politics, and also Jim Moore, who had written the major book on the criminalization process of abortion in the 19th century, both testified that there was absolutely no evidence that the legislators who did pass these laws in their states and also ratified the 14th Amendment, that they connected these two at all. And just to add an interesting, and I find amusing, although very important, comment from the historian Eric Foner, probably the best known historian now of the Civil War and Reconstruction amendments. I asked him whether he had ever seen in any of his research any link between the abortion criminalization and the 14th Amendment. He said no. And then he said, if the 14th Amendment was meant to protect the fetus, the embryo, et cetera, they could have written all individuals born and unborn or naturalized in the US, et cetera, because that clause begins all individuals born or naturalized. So this, as I think Aaron can probably say more about this idea that the embryo from conception is actually protected by the 14th Amendment is not an idea that has died among those who oppose abortion. But there has also been a very deeply developed counter history of the common law, which attempts to prove that the common law criminalized any termination of pregnancy before quickening as well as after. However, my own investigations of this and some European historians' investigation of these supposed cases that show this, thinking of an important article by Carla Spivak, show that the cases from the medieval and early modern period that purport to show this are actually cases of battery of a pregnant woman who therefore loses a pregnancy. They are not abortions with the consent of the woman, which is the way abortion is defined in the understanding of the common law. And then the other side, to which Alito has been listening, also does not accept what I believe is the fact that American law used Blackstone in the way I've described it, that is to say, before quickening, law doesn't protect the individual, because they look at a second clause, he said, that points out that a being can be said to have been there before quickening for purposes of inheritance. So, for instance, if a woman is pregnant when and her husband dies, but her husband has made his heir the person who will inherit, if that baby is born, even though it was only a pre-quickening embryo for him, that baby can inherit. And Blackstone recognized that what we would call a civil law issue. So the lawyers against abortion, whom Alito credits, take that second clause to mean the unborn at all stages was recognized by the common law for purposes of designating abortion, etc. So there is a counter history that I think is very, very problematic, but has quite a number of writers composing it and building it up.
Okay, thanks, Nancy. We only have 15 minutes, I guess, left. I think you really bring up something important about sort of the creation of a history and the disinformation campaigns that the anti-abortion movement and their legal scholars have been creating and pushing for decades, which I'm very concerned about. Melissa, I wonder if you might want to pursue this from your perspective and think about some of the effects in terms of other areas of constitutional law regarding sexuality and marriage and family.
Sure. Let me just first come back to a point that to sort of underscore something that Aaron and Nancy as well has said. this opinion is sort of the apotheosis of originalism as a method of constitutional interpretation. And it's worth noting that originalism arises in the 1980s as a response to the quote unquote living constitutionalism that they view as embodied by the Warren Court and a jurisprudence they see as excessive. Excessively liberal, excessively progressive. Interestingly, Roe is not part of the Warren Court tradition. It's part of the Burger Court, but it gets lumped into that as well. And so originalism, this idea that we looked for constitutional meaning at the time the Constitution or its amendments were actually ratified, has gained incredible purchase among conservatives. And it was lauded as a means of restraining liberal judges. So the idea here is that liberal judges cannot simply enact through judicial fiat their own proclivities. They're actually bound by the Constitution and its meaning at time one. But I think what we're seeing in the Dobbs opinion is that originalism is as selective and itinerant as living constitutionalism, and it can also be as purpose-driven as liberal constitutionalism it has been accused of. And so what we see here is Alito cherry picking basically from the history, taking what supports his argument and discarding what does not, and advancing this as the original view of the abortion right at the time that the 14th Amendment was ratified. And so I just cannot say that strongly enough. Like, this is a theory intended to restrain quote unquote activist judges that essentially underwrites an entirely new era of judicial activism. Separately, not only does it underwrite the dismantling of the abortion right, I think it very well may underwrite the dismantling of other rights. I have an op-ed in the New York Times today that talks about this. I think of these rights as protecting a right not to conform, and indeed protecting the kind of pluralism that the American society, American government has actually tried to protect over time. So the logic of the opinion is that Roe is a constitutional apostasy because it's unmoored from constitutional text and not deeply rooted in the history of this country. You could say that about Griswold versus Connecticut and the right to use contraception. You can say that about Eisenstadt versus Baird, another contraception case. You can say that about Lawrence versus Texas, which decriminalized same-sex sodomy in 2003. And you can certainly say that about Obergefell versus Hodges, which legalized same-sex marriage in 2015. If Roe is constitutionally infirmed, the same logic applies to all of those other precedents. And Justice Alito is at great pains in the majority opinion to sequester the question of abortion from these other rights. And he says the distinction is that abortion destroys a potential life, but that's not the logic of his analysis. His analysis is that it's not in the Constitution, it's not part of our history, therefore it's not a right. And that applies to all of these other things. And the only person on the court who seems to get that, or at least is willing to admit it in a forthright way, is Justice Clarence Thomas. And I found myself reading the opinions and thanking God for the first time for Clarence Thomas, because he has said the quiet part out loud. He writes that, yes, this opinion is limited to abortion, but he would go further. And he would invite his colleagues to reconsider the entire line of substantive due process cases, including Griswold, Eisenstadt, Obergefell, Lawrence, and perhaps overruling all of those cases unless some independent constitutional basis for those rights could be identified.
Thank you, Melissa. Aaron, do you want to add to that about some of the cases that you see coming up, given the anti-abortion movement's success in this?
Sure.
one?
I think that's a good segue. I mean, Professor Murray's absolutely right. Movement conservatives are not even close to finished with their assault on established constitutional rights. She's mentioned contraception and same-sex marriage, intimate same-sex conduct, but they're not even close to finished on abortion yet either, right? On the very day Dobbs was decided, Hadley Arkes, a prominent anti-abortion advocate, writes in First Things, one of, it's a very candid movement conservative publication talking about abortion. He says, Dobbs is just, quote, the end of the beginning of the end of abortion. That's the title of his piece. And he says, now that Dobbs has taken the first step, our work as anti-abortion advocates can begin anew. Right. And so what that work is, it's not a secret. They want to ban abortion everywhere in America at all points in pregnancy. And there are two ways they might do it. Nancy has alluded to one already. This is the constitutional argument that fetuses are persons to whom the 14th Amendment guarantees life that states may not deprive without due process. And if accepted, this would mean abortion bans are constitutionally obligatory, right? That if that sounds far-fetched, it shouldn't. The majority opinion explicitly leaves this question open. Justice Kavanaugh writes alone to say he doesn't think the fetal personhood argument is right as a constitutional matter. You can believe him if you'd like. But even if you do believe him, that means there are still 4 justices who presumably will adopt the fetal personhood argument. To get to 5, we don't need another liberal justice to retire or die at an ill-advised time. You just need the Chief Justice to retire, because when the Chief Justice is retired, he'll certainly be replaced by a Amy Coney Barrett type. That will be 5 votes to hold as a constitutional matter that there is no right to abortion anywhere in America. But that's actually the less likely scenario. I think the better strategy, if you're an anti-abortion advocate right now, is a federal statute banning abortion at all points in pregnancy. And I just want to flag this because for historians, and especially for the work that Nancy and Leslie and many others have done, history is going to come back, and it's going to matter in a big way with respect to a federal statutory abortion ban. And the reason is, as Nancy pointed out, all of the focus in the Dobbs opinion on history and tradition is what is the history and tradition of abortion as of the moment of the constitutional provision that guarantees the right or potentially guarantees the right at issue. And so for the 14th Amendment, which stops states from encroaching on individual rights and liberty without due process of law, the question is, what is the history and tradition of abortion? Is it deeply rooted in 1868? But if Congress were to pass a federal statutory abortion ban, they're not bound by the 14th Amendment. The due process clause that prohibits federal encroachments on liberty without due process law was enacted in 1791 in the Fifth Amendment. And so abortion clinics, abortion providers, should Congress pass a federal abortion ban, and to be clear, we're maybe 2 years away from that happening. There are already 160 Republican co-sponsors of a bill in the House to ban abortions across America at all points in pregnancy. Elections matter, the midterms in 2024. If a nationwide abortion ban were to be enacted, clinics should argue that violates the Fifth Amendment right to an abortion. And you might say, well, how can there possibly be a substantive due process right to abortion in the Fifth Amendment when Dobbs just said there doesn't exist one under the 14th Amendment? And I would probably agree that that's what this court will hold, but it will take a lot of gymnastics for it to get there. Because remember, if the history and tradition that matters is the history and tradition as of the relevant provisions enactment, then the question the majority would have to ask is, in 1791, is there a history or tradition of abortion? And the majority concedes, I think, it points to moral disapprobation, although surely moral disapprobation is not enough to take something out of the status of a constitutional right. Many people disapprove of contraception, same-sex marriage, but take it on the other side. There are many people who disapprove, think it's morally dubious for someone to take their children out of public school and enroll them in private school. There's a substantive due process right to send your children to a private school. If moral disapprobation is enough to get rid of it, Congress could pass a federal mandatory public school requirement. I don't think Justice Alito would be as happy about that. So all that to say, if the court really cares about history, the next frontier may well be this question about, is there a deeply rooted history and tradition of abortion right in 1791 that might render invalid a federal statutory abortion ban?
Can I just add something? While this may seem a far-fetched case to follow up on Aaron's, what has been striking me in thinking about this opinion and its implications is, of course, women only got the right to vote in 1920, let's say the 19-teens in many states. Black women didn't really get the possibility of voting till the 1960s. At the time of the 14th Amendment, no woman had the right to say anything in the polity. She could act in private life, but at the point a few years later, when a few women said the 14th Amendment had empowered them through its privileges and immunity clause, empowered them as female citizens to vote, and they went to the polls to vote in 1872, a Supreme Court decision, because one of them was prosecuted and took her case to the court. In 1873, the US Supreme Court said, no, you may be citizens, women, but that doesn't give you the right to vote. So there's a lot of history and traditions in the United States excluding women altogether from political participation and decision-making. So which history is going to be the one that this court looks to? It's a very, very disturbing question.
Melissa?
I think it's a terrific point. I really do think we're at the precipice of a major sea change in this court's jurisprudence. And I don't think that's a question of history. I don't think it's a question of methodology. I think it's a question of numbers. This is a 6-3 conservative supermajority. And I think they have been waiting for a long time to prosecute a particular agenda, and they have the numbers to do it now. And I think what we are going to see over the course of this term and next term is a complete realignment of what we thought constitutional law was. And we've been focused on the Dobbs opinion. I think if you zoom out and just think about what this term looked like as a whole, it really is astonishing what has happened. And I don't even think we've paused to reflect on the true reordering of constitutional jurisprudence. We've not only rolled back abortion rights and laid a foundation for rolling back other kinds of rights of intimate association, we have fundamentally reorganized our understanding of the Establishment Clause. We have expanded our understanding of what it means to have free exercise of religion. We've reordered our notion of government speech. We reordered our understanding of public subsidy for religious institutions. We are poised to rethink the relationship between tribes and tribal sovereignty and the United States government next term. We will also rethink affirmative action. We are poised to reconsider the entire underpinnings of the administrative state. It's not just abortion. This is about a use of history that is purposeful and purpose-driven, and not necessarily true to the historical record, because it doesn't have to be, because 6 people think it is what it is. And that's an exercise of raw power. History is written by the winners. They have won on this score. And the question is, will we allow them to continue winning?
Exactly. Thank you so much, Melissa. It is horrifying. It's a new world from what we've gotten used to. And I do think about law breaking, and this is how changes were made through many of the social movements of the 20th century and earlier, and the need for kind of collective solidarity, not just among activists, but like the medical profession. They were activists in the 19th century, and at the time of decriminalization in the 60s. The majority of the medical profession, they signed on to all the briefs and court cases to decriminalize abortion. And, we need to see, I think, a lot of action that's outside the courtroom. So I think we're supposed to wrap up. And thank you so much, all of you, for being here. And I think Jim is going to hop on to say goodbye.
Thank you. This concludes today's History Behind the Headlines. We very much appreciate the time and the work that all of you have put into this. I want to share a few final items before you go. First, last fall, the American Historical Association, in collaboration with our colleagues at the Organization of American Historians, sponsored an amicus brief in Dobbs versus Jackson. This brief, based on decades of study and research by professional historians you've heard it referred to today, aimed to provide an accurate historical framework as the court considered this decision. We will share a link to the brief in a follow-up email that everybody who has registered for this webinar will receive. We'll also share a link to the statement issued by the American Historical Association and the Organization of American Historians in response to the court's decision in the Dobbs case, which was publicized this morning by both organizations and endorsed by a number of organizations, and those endorsements are still coming in. Also included in that email will be a link to today's recording, which we hope you'll share widely, as well as information about how you can become more involved with the AHA. Links to the brief and the statement are posted in the YouTube event description that's on your screen, I hope. Finally, we want to express our sincere thanks to our moderator, to all of our panelists for giving so generously of their time, and to Jared Brubaker for his generous sponsorship of History Behind the Headlines. We also want to thank all of you, our attendees, for spending this hour with us. If you have any follow-up questions, please contact us at ahaonline@historians.org. If we have stimulated your thinking, if we have angered you, if we have pleased you, whatever you would like to tell us, we are welcome to hear. And especially if you're a member, we will respond. So thank you all for attending, and I hope to see you again sometime.